Hey y'all, Rob here with ATX Legal, here with part 3 of the Travis County Assault Family Violence Guide for 2023. And in this video, I'm going to be talking about the whole process, the court process, what are your court dates going to be like, what is trial going to be like if you get there, and basically how is this going to go. And this process I'm starting after the arrest, after you've been released from jail, because most people do get released. If you're in custody on a felony, it would go a little bit different, but you've been released and now what happens? Do I have a court date? Do I need to show up to court in a month? Since the COVID lockdown, things have been a little bit different in Travis County. You have to come to court a little bit less. Some cases will be handled by Zoom. Others will be handled just by the attorney there without you having to be present. And usually that's going to be the case for at least 3, 4, maybe even 6 months where the case is going, but you will not have to be coming to court regularly. At some point, typically the judge is going to ask you to come to court. A lot of times those court dates are just check-ins. The judge wants to see how the case is going. Is it progressing? What's the holdup with the case if it is held up? And is it something that's going to be needing to move to the trial docket? Now, how fast a case moves is going to depend on a lot of factors, but there are 3 typical ways that a family violence case is going to go. Now, the first way is if there's clearly not enough evidence there for the charge. Sometimes the complaining witness has made many false complaints before, and it's very obvious that there's really not enough to these charges that it's going to go forward to trial. Now, in these cases, we can get these dismissed rather quickly. Sometimes the prosecutor will still require classes, that BIP, the BIP class that I talked about earlier. Sometimes they don't require that, and they'll just go ahead and dismiss the case. I've gotten assault family violence cases dismissed extremely quickly because that evidence just isn't there. I would say that's a small percentage of cases, maybe 15% get dismissed right away. The next class of cases will go into a bucket I'll call FVIP cases. It's Family Violence Intervention Program for misdemeanors, or in the felony cases, it's pretrial diversion. And these cases are on hold for a little while, but the prosecutors will say, look, we'll dismiss these cases, but you do have to give us something. So you're going to need to go to classes, and you're going to have to go a time where you follow the rules, you don't break any of the conditions of your bond, and of course you don't pick up any new charges. If you do pick up a new charge in that time period, usually it's between 6 months to a year, then they're going to bring this charge back and you're going to have to handle both of those charges. Or the same as if you violate your condition of bond, they're going to bring this charge back and you're going to have to handle that charge. So these cases do result in a dismissal. So I recommend my clients accept these offers often when they are offered, but it does take longer than just that straight dismissal. So that's the second bucket, and those cases can take 6 months to a year, on the basis of how long it takes you to complete those classes and what the prosecutor is willing to agree to as far as when they are going to dismiss. Now, the third bucket is a little bit stickier and harder to define, and these are the cases where the prosecutor is really pushing back. Usually in these cases, the complaining witness wants to go forward with charges. It's something where they're not making up with this person. The relationship is over and they are definitely going forward, or there's just a lot of evidence for it. So even if the complaining witness doesn't want to go forward, the prosecutor believes that they can prove their case even without the complaining witness's statement, so they don't want to drop the case. Typically with these cases, what we have to do is just set them on the trial docket. And doing that doesn't mean we'll go to trial, but it does force the prosecutor to look really closely at their case and make that determination as to whether or not they can actually prove their case. And a lot of times by putting it on the trial docket, we are going to get a better plea offer. Maybe they hadn't offered the FVIP program before we put it on the trial docket, but after they look at their case, they realize this is going to be shaky. We're not sure if we can prove this in front of a jury. Why don't we offer the FVIP so we at least get them taking classes? But at the end of the day, the case is dismissed, so it's still a win for my client. But these cases can take a lot longer because you're putting them on that trial docket. We don't know when the prosecutor is actually going to give that case a hard look. And, they may make that determination that, no, this is one of those cases that we are going to take to trial. And that can take 1.5 years, even sometimes 2 years before it actually gets to trial. But for reasons which I will discuss later, I don't usually accept any kind of plea deal that involves either a deferred adjudication or a probation because it involves a family violence finding. And again, that will be discussed in more detail in another video, but it's just think of it as a really bad thing that you don't want to agree to. So therefore, when I'm getting these offers and they're not coming down to something that either leads to a dismissal or that FVIP program or a pretrial diversion, I'm usually counseling my clients to not accept the offer and go ahead and put it on a trial date. So when we do put it on the trial docket, you will need to be present for all the trial docket dates. And those trial dockets don't just include your case. It's going to have 10 or 12 cases. The judge is going to choose which case to put in front of the jury, and they'll usually choose the oldest cases first. Sometimes there's other factors. Maybe the oldest case isn't ready to go, so they'll go to the second oldest. Or often those older cases do get pled and they come to a deal, and now your case is up for trial. But you will need to be present for all those dates, and then you'll find out if your case is going to trial or if the judge chooses some other case. And assault trials usually last from 2 to 3 days. Sometimes they can go a little longer, and you'll need to clear that part of your schedule if you are set for trial. And it's important to note that when we do set it for trial, plea negotiations can continue. They can continue right up to the date of trial. Even in the middle of trial, you can come to an agreement with the prosecutor. And that's always something to keep in mind, because if you do get that offer that makes sense, even in the middle of the trial, sometimes you can end the trial early and get the deal that you couldn't get before trial. Now it might be available. Of course, none of this is legal advice for your specific case, but if you do want legal advice, you can visit us at atx.legal and we can set up a consultation.